Hello, everyone, and welcome to our webinar this evening on the importance of writing a will, which is brought to you by Franklin Templeton. Today, we will discuss why creating a will is such an important step in your life, especially as we journey through life. Writing a will empowers you to ensure your assets and possessions, and that your possessions are distributed as per your wish, providing you and your family peace of mind. To talk more about the process of getting started, we have today legal expert Nisha, and I'll be introducing her shortly. As we start the session, feel free to drop any questions on the chat, and please keep your microphones muted. We'll be addressing all your questions towards the end. So let me share my screen, and I will be handing this over to Nisha once I introduce. Just give me a second. So today we will be, the session is on protecting your legacy, a guide to will writing. Get Set Up is on a mission to help over 55, just a minute. Get Set Up is on a mission to help those over 55 years learn new skills, connect with others, and unlock new life experiences. Our goal is to reduce isolation, loneliness, and equip the community with the tools and knowledge to age independently in place. Our community engages in classes online as well through offline activities like traveling together over longer as well as day trips. Meet our legal expert and today's speaker, Ms. Nisha Aggarwal. The objectives for this class will be understand the significance of wills in safeguarding your assets and ensuring your wishes are respected. Learn about the legal framework and requirements for creating a valid will in India, including the necessary clauses and documentation. Discover effective estate planning strategies to maximize the benefits of your assets and minimize potential disputes or challenges. So what is the one thing you are hoping to learn today? Before that, let me just introduce the speaker. Nisha, in the area of private client practice, Nisha advises clients on the legal strategy for estate and succession planning and on the smooth intergenerational transmission of wealth. Over the years, she has acquired abundant experience in estate planning for beneficiaries based in the US and the UK. She started her career with S&G and Partners. She has worked closely with all the major banks in the country on several transactional matters and further advised many families on their estate and succession planning needs. So again, once again, request all of you to put your questions on the chat and mute your microphones. We will definitely address all your questions. What is an estate? Meet our expert, Ms. Nisha Aggarwal. Nisha, you can take it over.
Hi, good evening, everyone. Very happy to be here to conduct this session today. Yes, this is quite an interesting topic, and it remains interesting even for us who deal with it day in and day out. So let's get started with this. We all have heard of a will. We all know that it's a document that one should write. So let's, learn more about it today. Introduction that I work with a company called Warmond. We specifically do estate and succession planning. And this is the session I'm conducting to make you understand better about what is estate and succession planning and what it entails. So world over, there are only two tools for succession planning. One is a will, and the other is a slightly advanced planning structure called a private trust. These are the only two structures which work for estate planning. Of course, our today's session is limited to learning about the will and the requirements, so we'll stick to that. So we'll start with what is an estate, because people wonder, is it only that, what do I write? What does my estate entail? So let me just briefly put it that everything that a person owns upon their demise whether it is real estate, whether it is cash balances in the banks, whether it is shares in your demat account, even the car that you own, the paintings, your possessions at home, your jewelry, everything that you own is collectively called a person's estate. So when we say we have to deal with our estate, that means everything that we own in our name. And to deal with it, will is a document that one needs to put in place to write down everything, that how does all your assets which belong to you, how do you want to deal with it post your demise? How should your family or your executor deal with it? Who should it go to? And how should it be used? That is what a will document is put down for. So we can move on to the next slide, because estate is basically everything that one owns. We can move to the next one. Yeah. So what is estate planning and why should we do it? See, if we are all individuals living in different jurisdictions and under different laws based on our religion, whether we are a Hindu, Christian, Muslim, Parsi, we all have our personal laws which guide our inheritance. But yes, by writing a will, we can actually write down what one can, how your assets should be dealt with. If you don't write a will, a person's the succession laws take over, and your money and your wealth will be distributed to your family members as the law determines. So if you want any differentiation in that, then one must write down a will. Let me just give you a brief example, that if for a Hindu male, if one doesn't write a will, the law says that upon his demise, the assets will go equally between his mother, his wife or spouse, and his children equally. Although these are the people who are the loved ones who you may want to give to, but may not be necessarily equally. So if we want any differentiation in this, we must make sure that we write. On the other hand, for a Hindu female, it's slightly different. Mother is not a dependent of a Hindu female. So for a Hindu female, it's just her spouse or husband and the children. So this is the way the law determines. But of course, if a person writes down a will, you can give it to anyone, need not just be your family member. You can give your wealth away to charity, your friend, whoever you want to, you can give it. So it's very important that one writes down a will and the ratio in which the distribution is taken place. And also, when there's another important reason that one should write a will. We all have assets all over the place. It's not, we usually don't keep a consolidated list of it. So when one does write a will, it also acts as a consolidation document. Family can easily find out, okay, these are the bank accounts our family member had. These are the demat accounts. These are the real estate properties. Because if one doesn't share this, usually most of the people we come across, that they are always grappling in the dark, trying to find paperwork. And they also come across information with a checkbook or a paperwork much later, that there was this account which we didn't know and didn't deal with. So it also acts as a very good consolidation document, and also gives the family members clarity as to what was the intention of the deceased person. What did he want? Why did he do this distribution accordingly? In a will document, we can even put down reasons. Suppose you give one child more and the other child lesser. Whatever is the reason for it, you can write it down. These are some of the things that one can do in the will and put the document in place, so that when one passes away, it is easier. Of course, there is emotional strain on the family for the loss of the loved one, but at least we should make sure that there is less complication on the financial front and all these asset handling fronts. So we must put down a will in place. So whoever has not done it, please do it. We can move to the next slide, please. Yeah. So some of the considerations that one might think. So people, some people think, can I gift some of the assets during my lifetime? Should I hold on to it till I'm alive? So these are some of the thoughts. And then, depending on the age of the beneficiaries. You may want to deal with your assets in different manner. You may want to give some during your lifetime. You may want to hold on to some till the will takes effect. And also, as I mentioned, what is the ratio of distribution and why, these are some of the things one can detail. And also, another important factor that one should consider, especially if the children are younger, is the guardianship of the child. See, naturally, parents are the natural guardians of a child, but suppose in the unfortunate event that both parents pass away, we live in a patriarchal society. So the law determines that the child's custody is handed over to the father's side of the family. Sometimes this may not be practical. They may not be living in the vicinity where the child is. They may be living in a different city. Maybe the child is closer to the other side of the family. So these are some of the considerations one should give thought to and at least put down the name of the guardian. Because if one doesn't write down, the law determines and the court determines. So it's always good if one has young children to put down a guardian, and also to guide others who have young children. And as I said, the recipients could be anyone other than your family members. So if you wanted to give any money to a friend or a well-wisher, if you give them that money during your lifetime, they will have to pay tax because that would be considered as income. But any money which goes through a will to any person, even if he's unrelated to you, there is no tax for them on amount which they get from a will as a bequest. So if somebody's been good to you, you can leave a good amount to them in your will. Yes, we can move on to the next slide, please. Yes. So as I mentioned earlier, laws of succession come into play when you do not write a will. For Muslims, there is a Sharia law that applies, which is basically laid down very clearly. Even if they write a will, there's only 1/3 of their estate that they can deal with through their will. But for all other religions, if one does, it is guided by the Indian Succession Act. And if one does write a will, you are free to deal with all your estate as you please. So it's very important that you do put down the paper and put down your wishes on a paper so that your will can take effect after you're not there. Yes, but we can move on. Yeah. So what is a will? And people do ask us sometimes, of course, we haven't mentioned about probate here, but sometimes people do ask, okay, I write my will. Can I probate it during my lifetime? Can I have it effectuated during my lifetime? So the answer is no. Will is a plain piece of paper during your lifetime. It has no legal value. It only comes into effect when the testator or the testatrix who writes the will passes away. And that is when the will takes effect and gets its legal sanctity. So during your lifetime, you can write the will as many times as you would like. Yes, there are, you have to put down certain things that you have to be of sound mind. You have to write down clearly all your assets and the bequest pattern. It can be modified and you can amend it as many times as you like. You can make a new will and the other one will just get void, null and void. You write a new will. If you've written a will and want to do a small change, you can do that by adding a codicil to it. That's just a small change. The main will remains in effect, but you can just add one or two clauses that you want to. That's called a codicil. So one can do that during your lifetime. And we have this myth that people ask us, does will need to be on a stamp paper? Does it need to be registered? So one can write a will on a plain piece of paper. There is no need for any stamp paper. Of course, you write your details clearly, you write your intentions clearly, and you make sure you write that all your previous wills, any that you've written, are null and void, and this is a fresh will that you're doing now, and this will take effect. And two witnesses need to witness it and sign it, and they have to do that signature in front of you. They have to see you sign the will. That is very important. It's not good to sign the will and send it somewhere else to witness. That's not good practice, because if at all, for any reason, the will is contested, if the matter goes to court, it's not valid that the witness did not see you signing the will. So they need not read the contents of the will, but they should see that on such date and such time you signed the will in front of them. So that is very important. Registration of the will is not mandatory, but it's a good practice. A will is as valid even if it's registered or not unregistered. It does not prove its legality better one way or the other. But what happens is, if it's registered, if you've lost the original copy, one can go to the registrar's office and take a copy which is from the registrar's office. So you can retrieve a will, basically the registered will, because if you've just have a unregistered will and you've lost it, then it's difficult. So it's a good practice to register it. But even an unregistered will is as much a legal document as a registered will. Yes, so I think we can move to the next slide, Anita. Yes. So these are some of the requirements, as I mentioned. Yes, the testator's full name, address, etc. should be provided. One should shortlist who should be the executor of the will and put their name down. And the bequest pattern, as I mentioned earlier, should be clearly written, especially for real estate, because we do see that, if you have a home, you would like to leave it to your children equally or in equal proportion. And we see that many disputes happen due to this reason, that one may want to sell it later, the other may not want to sell it. So we should try and, put down the clause a little more clearly, that if, at least even if one wants to sell it, it should be immediately sold and divided. A little bit of more clarity we should put down so that we can avoid disputes. Any unclear language does give way for disputes. So we should try and be clear. Executor should be mentioned. Of course, in the later slides, we'll come and discuss who should be the executor and why we should think about their competence, etc. But yes, as I mentioned, signature, we should date the will, we should sign it. Witnesses should see you signing, 2 independent witnesses. Preferably, the beneficiaries should not be the witnesses. It should be 2 other independent people who should be the witnesses. And the person who should be writing it should be of sound mind and should be, writing it out of their free will. It's good to also attach a doctor's certificate, which just says that your physician can write a paper down saying, I have examined this person on such date. He seems to be fine and of, sound mind, and he's written down his will on this day, and I've examined him and he is of sound mind. So it's good practice to attach that one paper. If you think there are chances of dispute on that front in your family, it's always good to attach the doctor's certificate as well. Yeah, we can move on to the next page, please. Yes. So coming to a little more detailed discussion on an executor. So who should be the executor and what is the role of the executor? The executor is a person or a company who can be named, who will carry out all your wishes in the will. See, we do have people, maybe parents that live here in India, the kids live abroad. There is a lot of legal and admin processes to be completed to complete the bequest. One has written down, this should go to this person, this should go to this person, but who is actually going to write to the institutions, inform them of the demise, share the paperwork, and get the assets to the beneficiary's name? So depending on what all the assets, the asset categories, believe me, this is a lot of work that is involved for the executor to carry out. So one, your executor should be willing to shoulder this responsibility and carry out all this paperwork. They should be a bit savvy with the, what all needs to be done. Of course, there are companies and lawyers to assist with this. We have logged in from Bombay. In Bombay, probate is mandatory. So there is a process, court process to be completed, paperwork to be completed. So an executor is the person who can apply for all this, can sign and carry out all these necessary legal and admin processes so that all the assets, title and name change can take place and it can be handed over to the beneficiaries. And of course, the executor has a liability and is answerable to the beneficiaries and answerable to the regulatory authorities to carry out all this in a timely manner and to hand over the assets to the right beneficiaries and discharge their duties. So it's very important that the executor is capable of doing that. So there are some of the things one may need to look at for choosing the right executor. We can move on to the next slide, please. Yeah. So before you appoint your executor, these are some of the things that you may want to give thought to. That the executor's age, especially, please make sure that the executor is around, is a younger person who would be around to take on the responsibility. And as I mentioned earlier, it's not good to, because you're close to a friend who lives probably in America, to be named as executor, who will need to come down here to carry out all the necessary formalities. So location is another consideration. Competency, that they understand the paperwork, they can do all of it. There is tax to be paid, because you see, when a person passes away, before the assets are handed over to the beneficiaries, all the statutory liabilities need to be discharged. One has to pay the taxes, file the returns of the deceased person, and only then the rest of the money, and then give actually whatever liabilities are due. Suppose there is a bank loan, etc. All these liabilities need to be discharged before the assets can be handed over to the beneficiary. So this is the responsibility of the executor to do that. And also the time and commitment that is required for this position, if they are able to devote such time towards carrying out all this. Yeah, so this is basically, these are some of the considerations one must look at before appointing a person as the executor. We can move on to the next slide, please. Yeah, before we finish this and we go to Q&A, I would like to speak about one other topic, which is nomination. So people sometimes ask us, okay, I have nominated my, whoever should be getting my asset, my bank account has a nominee, the money should go to them. My share certificate of my flat in the society has a nominee, so I don't need to write a will. So let me clarify that nominee in law is just a custodian. They are not the legal inheritor of your asset. So suppose if you have, let me give you an example. Suppose you've not written a will, and you are a Hindu male, and you have, when the person is not written a will, we say that the person has passed away intestate. That means the succession laws determine the bequest of their property. As I mentioned earlier, that for a Hindu male, it would be his mother, his wife, and children in equal proportion. And the person may have named just his wife as a nominee because he intends that the money in the bank should go to his wife. But let's see how it will pan out. Nominee, as I said, is just a custodian. And because there is no will, the bequest will happen as per the succession laws. So whatever money is in the bank is to be equally distributed between the mother, the wife, and the 2 or 3 children that he may have. But so while the bank will hand over the money to the nominee and discharge their liability by getting a form signed from the nominee saying, I am discharging my liability by handing over this money to you, but you have the legal responsibility to hand it over to the legal heirs of this person. So it is then the responsibility of the wife to actually give it to all the others equally. She may or may not know this, but any other legal heir has the right to sue her if they want to. So it's very important that we don't consider nomination as just the end document for actual bequest. Will is the right document. And this is the same even for share certificates in flats. So just because you put a nominee doesn't mean the flat will be going to them. Yes, they are nominees, they are custodians. They can sign on your behalf when you're not there, but they are not the ones who will get it. It will go as per your will or as per your succession law. So please do make sure you write a will and put down all your thoughts in it very clearly. So we can open it for any questions.
start with, we have a question from Lena who says, do we need to register our will? If yes, what is the process and the cost?
So as I mentioned earlier, registration is non-mandatory, but yes, you can go to the sub-registrar's office, which is the same registrar's office where you go for property buying, selling. That's called the sub-registrar of assurances. You can find the nearest office. You can go and tell them you want to register your will. The government charges are just between 100 to 500, 100 to 500 rupees. It's a very nominal charge. They take your photograph, do your thumbprint impression, and register your will. If you do employ an agent to help you with it, then they charge anywhere closer to 5,000 in Bombay to help you register your will. That is what the cost is. But the government charges are just 500.
Yeah. So let me just go up and take the questions on the chat.
Sure.
Just a minute. Okay. So we have Meera who asks, does the will have to be registered at the registrar and on stamp paper?
No, your normal will, which is written on plain white paper, can be registered with the sub-registrar. It need not be on a stamp paper.
Is the will valid if the tester commits suicide? Yeah.
Yes, it is valid if the person is not living, doesn't matter how he dies, but yes, the will is valid.
Is it better to hire a professional firm as an executor?
Depends on the assets and the quantum of the assets. Yes, it is good to hire a professional firm, definitely, because they know the legal processes. But yes, they do charge a fee, and depending on the assets and depending on how much is the work involved, then one can evaluate if it makes sense. Otherwise, one can also employ a lawyer to do it, to handle the paperwork, and if any other person to do the running around to do work.
Okay. Can a brother or sister and his or her children have any right over the property or finances of a person if the person has not left a will?
So succession is, we have in our succession laws, there is a category of legal heirs. There is something called a class 1 heir. There is something called the class 2, class 3. So depending on the classes of heirs. So for generally a person, class 1 heir is just his wife and kids. So if there are any class 1 heirs living, the assets go to the class 1 heirs. Only if there is no surviving class 1 heir, then the circle moves to the class 2 heirs, which will come to the brother and sister. If there is no class 2 heir, then it goes to the class 3 heirs. So depending on which class one fits into, class 1 has the first priority, class 2 the next, and thereafter.
If nominee doesn't agree to sell the flat, whereby will he get only 40%? Then what can executor do? Going to court is wasting too many years.
Sorry, I don't understand the question. If nominee doesn't agree to sell
Doesn't
the
agree
flat?
to sell the flat, doesn't agree to sell the flat, whereby will he get 40%? Then what can the executor do? Even I'm not very sure what exactly.
Yeah, somebody will have to
Nisha,
clarify
can
the
you
question.
just
Whereby the will of his mother, he gets only 40%. But he is refusing to sell. An executor, what can executor do?
Yes. So as I mentioned, if real estate is given to 2-3 people, then everybody has to sign. Unfortunately, it cannot be sold just by one person agreeing, and the person who wants to sell, as I say, the person who has 40%, if he doesn't agree to sell, the person who has 60%, they can only sell their 60% independently, and you have to have a buyer who's willing to buy only that 60%. So it's
in a flat, nobody will buy 60%.
exactly. So this is the biggest reason of disputes in our courts, because it's always good that whatever real estate is given to your beneficiaries, less, more. If you have two try to give one each and not have 50% in each of them to all of them, because that makes life miserable, because nobody has independent right of any property. But to answer your question, if he has 50%, 40%, and if he's unwilling to sell it, there is nothing the other person can do. Even if they go to court, they cannot force the other person to sell it. You can't force the other owner to forcibly sell it. It is his wish that he doesn't want to sell it, and he owns it. So you cannot force your joint holder to sell it.
So he becomes
Yeah.
the owner. He's occupying it. So he becomes the owner.
No, you said that he owns 40% of it.
Yes, and he's in
Yes,
possession.
yes, yes. So
So
if
how will the other
owns
50%?
if he owns 40%, he is part owner of it. And if he's occupying it completely, then it is a court matter, definitely.
No,
And
he's
this is,
not occupying. He'll just put lock that I'm the son, it's mine. Others are daughters.
so as I mentioned, he's part owner. So the other owners cannot force him to do anything.
So they have to write off the other.
No, they have to go to court to fight it, unfortunately.
Yeah, the court we read in paper, it's taking so many years.
Yes, that is the unfortunate part, that in our courts, this real estate dispute of joint property and one person not wanting to sell it, the others wanting to sell it, this is the most common problem in our courts and the cases there.
Okay,
So-
let's take the next question. Is there an expiry date for executing the will?
There is no expiry date, but it's definitely you'll have to deal with the assets immediately after a person's demise, because if the assets are, an asset has to go to according to the Transfer of Property Act, any asset cannot be nameless. If the person is deceased, it will be transferred to somebody's name, right? So it should be moved on to the next person as soon as possible. But yes, sometimes this transmission takes very long, even if there is a dispute in the family. We personally know of cases where the assets are named as the estate of the deceased and disputes are in courts for over 20, 30 years. But yes, if the title is clear, it should move to the beneficiaries immediately, because I'm sure the beneficiaries who are named in the will want the assets as soon as possible as well.
Yeah. Can we register the will in another state?
You can register wherever you have your ID. Usually now it has become even more that wherever your Aadhaar is, that's where you register it.
Who is entitled to the assets of an unmarried aunt?
So because unmarried aunt, as I told you, she will not have any class 1 heirs because she doesn't have a spouse or children. Then it is class 2, which is her siblings.
Executor passes away.
Parents and siblings will come into that class 2. So depending on the religion, depending on the class 1 and class 2.
Okay. Executor passes away before the demise of the will maker.
Yeah. So it's always good to name multiple executors, say 1, 2, and 3. If number 1 is not around or is unwilling, they may be around. Sometimes they may not want to take on the responsibility at that time. They may not be able to. So it's good to have 3 people saying this person, if not this, then this person, if not this, then this person.
Okay. Can the executor be a relative?
Yes, executor can be a relative.
Yep. And can witnesses be relatives?
They can be relatives, but not beneficiaries of the will.
What if a woman has a nominee and doesn't make a will?
I mentioned that nominee is just a custodian. So if she does not make a will, and if she's named her sister as the nominee and she has a husband and children, her assets will go to her husband and children. The sister will just be a signing authority, will have to hand over to the husband and children.
Is there a template that we can follow to start with?
There are many templates available online, but I would strongly suggest you get it done by a professional so that ambiguous language does not lead to confusion.
Okay. If will is not written, then what happens?
If will is not written, depending on your religion, succession laws will determine how your assets are distributed.
What if the executor specifies in his will to sell a bequeathed flat and divide the proceeds equally between the nominees?
Yes, so one can say, I live in this house, but when I die, this has to be sold and the money should be distributed amongst my 2 children. And one can write that.
If,
The executor will have the responsibility to find the buyer, sell it, and then hand over the money.
if will is a valid one, but not registered nor probated, how does one claim financial assets after more than 20 years of the demise of the testator?
So one can write to the financial institutions, but each of them have their own documentation. Each of them have their own legal and compliance team. They will ask you for, also depends on the amount. We do practically see that if the amount is very less, banks do hand over with disclaimers. If there is anything over 50 lakhs, they ask for a lot of paperwork. They will ask you to bring a court paper, like a letter of administration or any court paper for them. And each and every organization has a different one. It's not standardized. So depending, once you write to them, they will give you the list, what is required on their part, and you'll have to fulfill that and you'll be able to get your money back.
Can executor be beneficiary?
Yes, executor can be a beneficiary.
Okay. How does one will a joint property, which is in the name of husband and wife or both?
Sorry, I didn't get your question.
How does one will a joint property if it is in the name of husband and wife? Both
Okay.
of them.
So let me clarify this. When there is joint real estate property, if there are 2 people owning it, until and unless the deed does not mention that one person's share is 90% and the other person's share is 10%, it is deemed to be equally owned. And many places, the husband may have paid for the full property. He may have added his wife's name in the property. But in real estate, it's deemed to be equally owned. Okay, this is very important. And when one passes away, they can only will their share, which is 50%. So let's take a scenario that husband and wife own it, and the husband has passed away, and he has his wife and children, no mother, and he has not written a will. And so let's assume he has 2 children. So his share, which is 50%, will be distributed 3 ways because his wife and 2 children will become equal owners of his share. So his 50% will go to his wife and his 2 children in equal proportion, and the wife will continue to hold the 50 that she holds, and 1/3 of the husband's 50% will belong to the wife, and the 2 children will have 1/3 of the husband's share.
That was clear. Thank you. A widow doesn't make a will. Who will get her property?
If she has children, it will go to her children. If she doesn't have children, then will go to the class 2 heirs, which will be her parents and her siblings.
What if there is no will and other siblings don't want to sign on the bank papers even after 10 to 12 years?
It's going to be a deadlock because the bank will need signatures for them to release their rights if there is a legal heir, because they will not. But as long as then one should go to court and get a paper that these are the legal heirs, and at least you get your share, then you can leave the others who don't want their share.
Yeah. If the will is registered, still a married girl can, so what she's asking is, can a married girl claim equal rights?
Is it from the parents' property is the question? Husband's property? I'm not sure what is the question. Married girl, I presume that in a parent's property, maybe the brother is asking this question, can a married girl claim a right in her parents' property? Yes. Now, whether it is a girl or a boy, married, unmarried, all children of the couple is entitled to the property if there is no will. If the father has written a will and handed over everything in the will to the son, then she can't claim it because he's written a will and has willingly and voluntarily given everything to his son. But if there is no will, she has a rightful claim to equal share in the property as much as her brother.
Can a single will be made between husband and wife with the clear instructions that on the demise of one, all the wealth will go to the other? Thereafter, on the demise of both, the wealth to be distributed with specific instructions.
Yes, this is called a joint will. But yes, it can be made. Then what happens is, upon the demise of one, the transmission of the assets becomes difficult. It's always good to write each of their assets in each of their wills. And I must make one thing clear, that when you leave your assets to your wife, it will then belong to her. You cannot in your will say, I'm giving to her, but post her demise, she should give it to my children. You cannot have a conditional bequest for later. That is invalid in law. You can only give it to a person, then it becomes their wealth. They can give it to XYZ. They need not follow your instruction. Your instruction is valid only for your assets in the first level.
What happens if the wife expires first in a joint property?
So, as I said, if she has left a will, her share will go according to the will. If she says, I leave my share to my husband, and if he is the other holder, then the whole thing will belong to him. But if she's not written a will, then the bequest will go through as per the succession laws. Even the children will have a right. And if she's written a will and she's given to her children, then they will part own along with the father. Depends on what the joint owner has done in their documentation.
Whether copy of the will can be given to the beneficiaries for their information, and where is the will to be kept?
Yes, it's usually good to keep it in a place where your beneficiaries know where it is, in such cupboard or such locker or with such company. We as a company act as custodians of the will, and we charge an annual fee to keep the will as well.
Okay. Is the
Yes,
will?
one can, sorry, I didn't answer that completely. Yes, one can show the will to the beneficiaries. There's nothing wrong in it. It's only when there is a dispute, you feel you don't want to tell them, then it really depends on the family situation. If you have cordial relationships, it's fine to share the contents of the will with your children. There's no harm.
Okay. Is a will valid and legal if it is signed by the maker and signed by two witnesses? Is it necessary to have it registered?
No, it is not mandatory to have it registered. If as long as the testator has signed it, dated it, and two witnesses have seen the testator sign it and have signed the will, that is a valid will.
Are there specific considerations for leaving assets to family members or charities?
So it depends. That is a personal choice. When people have a lot of money, they do segregate between charity and children because they are of the thought that too much to be given to children also corrupts their ambition. So it's really dependent on family to family and their own thought process. There is no one, rule that fits all. It's really dependent on situations.
What happens if the will is not shared with all joint beneficiaries?
I think the question probably is that maybe two beneficiaries have the copy of the will and they are not showing it to the other beneficiaries. Then they should go and demand that right from the court, saying there is a will my father has left, and I am a child or a legatee, and I need to see it, and they are not showing it to me. They'll have to go to court to ask for that right to see the will.
How do you will your jewelry which is in the locker?
So it's many people do different things. They sometimes I have seen people photograph the jewelry piece and write people's names and the beneficiaries' names against that and attach this as an annexure page to their will. Or some of them have two separate lockers with each child as a joint holder in that locker, so that locker is accessible by that child, and they leave it in their will that locker number so and so, I have left jewelry, this belongs to this child of mine. Or even in the same locker, they put two different boxes with two different names on them and contents. So really dependent on how one prefers. Also, they sometimes even generically write that I have approximately, 100 grams of gold or whatever. I would like my children to amicably divide it between themselves. And if they are unable to, I would like the executor to do the division.
Okay. What happens if the flat belongs to the husband, wife, and two children equally?
Yes. So as I mentioned that whoever passes away, what is written in their will matters. So if the husband passes away, then if he's written in his will that his share is to go only to his wife, then she will become 50% owner. If he's written that my share should equally be divided between all three joint owners, then each of them will become 33.33% owner. So really depends on what they have written in their will.
Is a sanity certificate required if one witness is a doctor?
Well, a sanity certificate is not mandatory, but if you feel that there is dispute in the family and the members might refute saying, my father didn't know what he was doing, he was going through this ailment and that ailment, and what he's written is this will is not valid because he was not in his right senses. If one feels that there is any such possibility, it's good to have a sanity certificate.
In case of joint will, giving assets between husband and wife, what happens if both die together in an accident? And in such cases, how do you make a will?
So even when we make a will, we always say, I'm going to leave it to my wife, suppose. And if she were to predecease me, or if she and I were to pass away at the same time, then the asset should go to this person.
Can ancestral property be made? Can a will be made for ancestral property? That's what she wants to ask.
So ancestral property is a very different subject. It is defined as something which has been undivided property for the past 4 generations, etc. That's a very complicated subject, cannot be answered in one line. But yes, if you make a will, you can, add clauses saying whatever I've not written in my will, which may come my way, which I may inherit, is to be given this way. So one can address it in a generic way, but you may not be able to pinpoint your share there because it is ancestral. So it wouldn't have devolved upon you, and you may not have the title of it.
Can the if word be used in the will?
Depends, if I inherit anything from any side of the family, then that inherited property should go to this person.
If a wife expires, does husband have any right on her ornament, that is Sridan, or only children will get them?
Sorry, can you repeat that question?
If the wife expires, does the husband have any right on her ornaments, or does it go to the children?
So if the wife dies and there is no will, all her property will equally go to husband and children.
Okay. What is the
yes, to answer that question, husband will have a right on it.
What is the meaning of probate?
So probate is a court process where you apply to the High Court of, where probate is mandatory in some cities, and it's, good to do in some cities because there is a fee associated with it. In some cities, it is a percentage of the assets. Some city, it is a flat fee. In Mumbai, currently, it is a flat fee of 75,000 to probate a will. So you make a probate application to the High Court, depositing your will and giving the information that here is the deceased person's death certificate, here is the will, and this is the probate application. We would like this will to be probated. This is a process whereby the High Court then puts up a notice saying this person has passed away. There is a 30-day notice. If there is any liability in his name, please speak up. Anyone who has a claim on his property, please speak up, etc. They ask for affidavits and NOCs from all the beneficiaries and his legal heirs. And after a certain point in time, which is usually 6 to 8 months to 12 months, the High Court then validates the will with its stamp saying this will is probated and good to be executed. Thereafter, the executor is free to go and show the probated will and get the assets transferred.
If you have a single child who's married, is it necessary to make a will?
Depends. Yes, if you are a male, you have a mother and a child and a wife. If you pass away, then your property will go 3 ways. So if you want to give all of your property to your single child, then you have to write it down.
If my son sells, then gives the share to the to daughters, is it conditional will?
No, if you write down that post my demise, this property has to be sold and the money has to be shared between kids, that's not a conditional will. Conditional will is saying that here I'm giving this property to my son and he should give it to his son. That is conditional will.
Can a will be probated many years after the demise of the testator?
Yes, it can be. I'm not sure of the period that I haven't come across a delay, because sometimes one finds a will much later as well. You don't know where the will is. You found it later, so it can be probated whenever you find it, and that's not an issue.
So how can seniors ensure the fair and equitable distribution of the assets among the beneficiaries while minimizing potential conflicts or disputes?
By writing it down clearly what their intention is and envisaging situations. As I mentioned, that holding joint property is a big issue in leaving disputes for the children. So usually it's a good, one might be emotionally attached, the other might not be emotionally attached to the property, but the emotionally attached one may not have the wherewithal to buy out the other one. So one needs to be practical and leave clauses so that if one is able to buy out the share of the other, fine. Otherwise, in 3 months, this has to be sold and divided. It's better to be clear so that they don't hold each other at ransom.
Whether a joint will with the condition is valid, is a joint will with condition, is it valid?
Conditional bequest is not valid in law, as I mentioned. You can only give it to each other, and that's it. After that, you can't say if my daughter is married to, what is constitutionally not valid, you should not write in the will. That will be a void thing. You cannot say, okay, if my child marries a Christian, then they're out of the will and things like that, because we live in a country where the laws allow you to. So anything illegal like that written will not stand in the court of law.
There's another question which says, should a will be registered or can just be written and kept at home? I think you've already addressed this question, that it doesn't have to be registered.
Yeah, it's not mandatory, but it's good practice to register it. Yeah.
Yeah. If a mansion is joint property of 4 generations, if it is sold, how would be the distribution agreement for such an asset?
This is a specialized subject. I would not like to comment on the distribution of ancestral property. It's a complicated subject. One needs to peruse the papers. One needs to see the shares. One needs to see the documentation and only then advise on it. I would suggest they take legal advice from a property lawyer.
If a son sells the flat, then can the son refuse to sell the flat to retain 100%? I'm not very sure of what you want to ask, Rita. Can you just please put it down again clearly? And the next question is, at what age should one get a will registered?
So there is no age to write a will. One should write a will anytime. In fact, We have many clients who are in their early 30s writing a will because there is asset. In fact, the younger the age, more important to write the will because you may be a young couple, you may be the bread earner. The fact is you'll have young children, and if God forbid something were to happen to you, your asset will go to your wife and child. Then there might be another partner in the picture for the wife. So in fact, it's very important that you secure your minor child's interest or your wife's interest as you deem appropriate, even in early ages. It's not age related. One must write down a will. It's a very simple piece of paper. I don't think it requires much effort, but yes, one does need to devote some time and energy to it to have it in place.
Okay, last question for today. Can my siblings contest my will if I don't leave anything to him?
Everyone has a right to contest. Anyone can contest anything. Whether it stands in the court of law, whether the court admits their application to contest is upon the court. If they prima facie see merit and whether they admit the application or they dismiss it, it's up to the court. But yes, anyone can go and dispute anything in the country.
Okay, I think we are done with, we've addressed almost all the questions. So thank you all for joining us today in this session, which is brought to you by Franklin Templeton. We hope you've gained valuable insight into this crucial aspect of planning for the future. Writing a will is not just a legal requirement, but a way to protect your loved ones and ensure your legacy lives on as you intend. If you have any further questions or need assistance with will writing, don't hesitate to reach out to our support team. We will note your request and connect you with a legal professional or an appropriate advisor. Please refer to the form in the chat if you wish to seek an inquiry. We'd also like to thank our speaker for the evening. Thank you, Nisha, very much for your time and for sharing your knowledge with us this evening. And thank you all once again for logging in. For more such sessions and insightful articles, you can research for Get Set Up India on the App Store and download our Android app as well. So thank you very much, all of you. And it was a pleasure having you all here. And thank you once again, Nisha.
Thank you. Thank you for having me.
Everybody.
Thank you very much.
Thank you. Bye-bye.